Duncan, this isn't your field. Copyright's not your field. Open access isn't your field. But critical legal studies is. So I wanted to hear your reactions to this piece against the background of maybe sharing some tools and tips and tricks for an audience that may want to participate in it.
When Sean described his ideas of the general approach, the internal external critique, those are absolutely foundational for critical legal studies, but as his presentation suggested, they're shared by the critical community in general. So I think rather than looking at CLS in relationship to Severin's piece, I'd like to actually critique it. That is, present my own understanding of it, emphasizing how it fits into the overall critical project, and then express my sense of a possible way in which it might be taken a little further than she takes it. There, let me begin with Severin's position on the bundle of rights theory of property. So in those papers, she does something that's extremely un-French and very much in the American critical tradition, which is she basically endorses the idea that the concept property, understood as an abstraction, is not capable of generating, because of its internal disintegrated property, ideas about what to do. So the concept of property actually already incorporates a large number of different sub-entitlements. So if it's the right to exclude is actually very complicated. Sometimes you can exclude and sometimes you can't, because sometimes another property owner's right of use will come into direct conflict with your right to exclude, and the concept of property doesn't solve the problem of where the right to exclude ends and the right to free use, by the way, very relevant, or the privilege of free use, where that ends. So that problem with the basic abstraction of the property rights is the exposure and development of the consequences of realizing that property doesn't solve the problem of the boundary between the right to exclude and the right to use of the other party, is foundational for critical thought in law in general, and it's basically dates to the work of Hofeld at the beginning of the 20th century, and it's very, very powerful. Once you adopt it, discussions of what to do about property, including intellectual property, take on a new cast, because you can't do it reasoning from the concept of property. You have to accept the possibility of a million different variations and subversions of property, which are infinitely variable according to the circumstances. And in this case, you might have an argument that you didn't want any of that, that there were reasons not to split it up and divide it. And Henry Smith famously offers those reasons, I'd say completely unconvincingly when looked at as an overall position, but certainly there are policy reasons to make property more or less uniformly not broken up. So maybe you don't want it to be the case that trespassers who are strangers have different status than trespassers who are neighbors. Maybe you want them both to be treated in exactly the same way. And so that would be an argument for not disintegrating, but you need an argument about why you want to treat them in the same way, or why the neighbor and the stranger should be treated differently. So you need an explanation in every case. That's Severin's starting point. So when I read those pieces and looked what she was going to do with it, I thought that the two things that are very striking were the endorsement of the need, when you try to figure out how to disintegrate and reconsider, for a consideration of distributional consequences. If you're just reasoning from the abstraction, you don't do that. In fact, it's forbidden, if you're to be free to the method of abstraction, to look into the question of a non-juristic or extra-juristic consideration, like who gains. If the concept is the law, then all that stuff becomes irrelevant. So clearly she endorses the idea that you need a distributional approach and consideration when you have disintegrated intellectual property and are trying how to configure it. Of course, you recognize that it's already pretty disintegrated, but people don't admit it. So an important part of the gesture is to show that it's already less coherent, already contains elements that look like some are associated with one side of the divide and some side of the other. And, you know, Peter Jaszi formulated it. I was the first paragraphs of his famous article are like a critical legal studies manifesto that doesn't mention critical legal studies. It's a very striking gesture on his part. So there he has a fundamental contradiction, which is just the one we're talking about the, you know, the use, the free use versus authorship is understood as a basic contradiction that's built into the field. So in all of these respects, this is amazing. So then we get to the very striking gesture of reconceptualizing free use as a mode of commodification. You can't help saying, well, wow, that's pretty powerful. So basically, you free people, this is directly addressed to Sean, you think you're decommodifiers, but you aren't decommodifiers at all. You're participating in the ethos of decommodification, which we all understand to be extremely progressive. So we recognize the commodity as a basic evil structure of the world, and the commodity form generates all kinds of bad consequences. Wow, we're outside the commodity form in the realm of the free, very much like the early days of the internet, when people said the internet can't be regulated. Therefore, the internet is a dramatic new source of human freedom because it's not regulable. That was so wrong. I mean, obviously, its wrongness has never been more evident in the pandemic world of China. So that gesture then is under sharp attack. The free here is just another commodity relation. In fact, between authors, however they're conceived, and users, still it's a commodity relationship because that which was produced by the author is now floating around as a commodity that can be appropriated and used, just like other commodities that are accessed, but it's not decommodified. My feeling about that stage of the project was I had 3 criticisms of it. And the lecture is a full response to one of them, but leaves in place as a suggestion. And these criticisms are not criticisms of something done, but of something not done, which is, I think, more than just, well, the paper wasn't about that. I think the project doesn't have much complete coherence without these other things. But the first critique was, in those early papers, there's a commitment to the author as a real human being, as she says, not to the image of authorship, but to the actual humans who are authors. And the distributive point of view is from their point of view, she's saying. Now, there the problem seemed to be that there wasn't the actual attack on the idea of the author. So the author figures as the real person, not the romantic figure, but the critique of the author as a concept is external. Peter Jaszi's paper says, once we've got this reified author, there are all kinds of bad consequences. We have to understand the commodified author. What this one does is get rid of the author in a different way. So it's not that the construction is an historical artifact, which is a really important contribution of the article, the historicization of the author as a legal concept. This is not the legal concept. What this is a demand to put at the center the actual social process of creation of the thing that will then be reified into a commodity in one way or the other. So it's behind the author rather than what follows from the creation of a concept that has legal consequences. Now I want to make a pure quibble, but this is an old white male, let's say even an old straight white male critique. Your claims, Severine, let me say just directly to you, your claims of inspiration are absolutely, totally plausible. All of the feminism, Donna Haraway, intersectionality, we speak intersectionality, that's the language of the moment. But for me, the actual origin of the idea of insisting on the collective character of the creation of things in the world is Marx's essay, The Economic and Philosophical Essays of 1844 and 1845, in which Marx develops elaborately the idea that the creation of the things that will become commodities is inherently social. No one is an individual creator. He's actually focusing on the Industrial Revolution, where in the Industrial Revolution, it's constantly breaking up the process of production, makes the participants experience themselves as alienated from the process of collective production of the thing that will be of use. So that's my inspiration. And I'm not sure, I think there's some sense in which there's a long, long genealogical train that one might trace from that manuscript to Kim Crenshaw. It's actually possible. But I prefer to jump and say, there is an incredibly powerful thing that you share, not that they have a common genealogy, not that one comes from another, it's a new invention. And in that sense, I think it's your new invention, because I don't think you can really understand your sources as having really produced the thing that you're interested in. I think it's original to approach it the way you approach it. So now here's my critique. This critique goes to the early formulations of not of ecology, but pre-ecology, but it's to the idea of the relational, all those concepts. A basic thing that happens in critical thought is that the demand on the critic to produce an answer is a very strong demand. A basic question is whether you want to answer with a counter concept. So your proposal, if we look at it in the domain of what we should aspire to, can be, if it's purely aspirational, as is the manifesto that you discussed at the end of your talk here, then it's easy to listen to it and try to think whether one agrees. And when I think about your ecological conception, I think, yeah, I agree with that. I feel there's no cost to agreeing because I don't feel that I've committed myself to anything in particular. And it seems to me, this is a typical crit move within critical thinking, that it's sort of like the idea of property. Once you've deconstructed property, well, we do want some kind of protection, some kind of freedom. It becomes a very vague injunction. So I experienced the ecological conception like Marx's conception of work in 1844 as vague. Now, that doesn't mean I don't agree with it, because I do agree with it. If someone asked me, what do I believe in? I'd say, I'll take Civilian's position and I completely endorse it. That's my position too. But again, in the critical legal tradition, it sounds here as though, again, just as you might say that Sean, in the world of freedom, and particularly Larry Lessig, are guilty of an image of decommodification through the idea of freedom. The question is, are you outside commodification or not? So the minute we start talking about how you would make a creative, an understanding of the license as based on taking into account, say, the colonial dimension or the cultural dimension, one suspects that the minute we start talking rules, we're right back in the commodification dimension. So when you're talking rules, you're once again inside the logic of the commodity when you restrict the freedom in the free license. So now you're going to have a new, Henry Smith would say, oh my God, you're going to ruin everything, because now you're going to once again separate out and take the sticks in the bundle and reconstruct them for a new bundle that will be much, much more complicated. So when you take your work, when you publish it, don't publish it, all these things, who you are, there's going to be a whole complex of who can do what with respect to the various interests that are disregarded in the production process. So recognizing its collective character and its culturally embedded character is, I think, great. And I think that has changed my understanding of the dilemmas of copyright. But it looks as though the jurist, is then going to say, okay, so now you want a different commodity, you want to redefine the commodity, you rearrange the sticks, absolutely. When we rearrange the sticks, we'll take all these different interests into account, and then we'll have a new commodity and counter commodity in each of the different people with their own sticks. So the public will have different sticks in its bundle of privileges, restricted in different ways by the rights of authors. I'm not against that. In our fallen state, critique means to me giving up the idea that, say, the image of ecology will take me beyond my agreement with the political commitments of an aspirational type. So I'm an egalitarian. I'm welcome to be an ecologist in my ideas about intellectual property, if I had any ideas, which I don't. But then the question, and I imagine this is a totally French question, which is, speaking as a legal positivist, maybe as a Jacobin legal positivist, then, well, when you say, what are you going to do? I didn't experience what you proposed about that as having any relevance to the jurist who's going to say exactly how are you going to reconstruct it. And now I imagine this would be the last part of my critique. So in the shadow of what you're saying is law. You've deconstructed the unit of abstraction. You haven't proposed either another unit that's abstract with consequences as an abstraction, but nonetheless, you're talking about law reform. So when you're talking about law reform, there is in the critical literature, which I think is highly relevant to your enterprise, the question of the critique of legal reasoning or the critique of legal construction. And that's another dimension of critique than the one you've blown open with your discussion of authorship. So it would seem like what you're saying is not consistent with the rule of law. And the reason for that is that the only conceivable way to deal legally it is the question of either doctrinal writing or legislation or judicial interpretation. It's going to be an unbelievably complicated balancing test. So any legal norm that's based on your conception is going to require the shattering of the judicial inquiry into the logic in the French mode into a totally post-conceptual social mode of balancing tests based on identifying a multiplicity of interests, which could be infinite, which will then have to be arbitrarily constricted to an intelligible set of interests, with the consequence that law disappears. Now, that idea could be stated as, if you believe in proportionality and the judges of the European Commission of the Court of Human Rights, which people constantly say, or the European Court of Justice, that discourse against proportionality strikes me as ridiculous. So that aspect of the French categorical reaction, proportionality is the death of law, is, I think, silly, but you've got to have a way of dealing with it. So the crit way of dealing with it, I would say the critical way, not critical legal studies, because critical legal studies is not about, has, well, not, yeah, sure, critical legal studies, but critical in general, is the grow up answer, which is a very powerful but infinitely controversial kind of assertion. Wait a minute, you can't have the rule of law the way you want it. Now, that's a deep attack on something people want. And it's not just French post-formalism, it's in the United States, it's everywhere. So I think I have an answer to that, which is you can't have what you want. But you don't seem to recognize the existence of the problem. So that's my last critique. So let me say again, I actually have no reservations about your project, except the ones that I've stated, which are not about what's wrong with it. It's about whether, if you take it seriously to the limit, you're going to have to confront a certain kind of challenge for which it's very unclear to me what your response will be. But thank you, Severine, very much.
I just wanted to jump in for a moment to what seems to be the fundamental question here, which is how does one go forward with anything that resembles a classic, if we may call it that, open license without falling back into the meshes of commodification. I don't know, I assume so, but I think it may be worth thinking about and perhaps even addressing in the paper the recent work of the Local Context Project and the traditional knowledge labels. It obviously relates poignantly to the question of how one might proceed with initiatives like the large-scale digitization of traditional arts and other museum objects. And the notion is in effect to kind of abjure the form of the license, the form of the claim followed by the permission, and to embrace instead the idea of an expression of preference which, because it is not linked to an authorial claim, can be made more or less plausibly, depending on how that expression of preference is generated, on behalf of a community, in this case custodial communities, but extended arts communities would be eligible as well. And when I first looked at this, even though I'm a huge admirer of everything that Jane Anderson does, I was a little skeptical because I was stuck, so to speak, on the license model, which after all is the precondition for enforcement, which after all, as we know, is the precondition for compliance, except of course we know it isn't. So it isn't in fact evident that expressions of preference are without power. To the contrary, it may well be that they have a kind of power that in effect transactional expressions do not. So I don't know if this is a way out of any of the, or a way forward, but it seemed to me to have a direct relevance, and I wanted to raise it.